With us now, CNN legal analyst, former federal prosecutor Shan. Shan, thanks for being here. Good Monday morning to you. And let's take a listen to a little bit more of what the president said in that interview that Chris Wallace did, which Jim and I were just saying. He did a remarkable job and got a lot out of the president on that. When he asked if he would not sit down with Mueller, and then there was a little bit more of an exchange, let's just play that.
I think we've wasted enough time on this witch hunt, and the answer is probably. We're finished.
What are the odds? 1 in 100?
I don't do odds. I gave very detailed...
casinos, sir.
You're right, and very successfully, actually. We gave very complete answers to a lot of questions that I shouldn't have even been asked. And I think that should solve the problem. I hope it solves the problem. If it doesn't, I'll be told and we'll make a decision at that time. But probably this is the end.
So if probably is really it is the end, what legal power, if any, does Mueller have and his team have to compel the president to answer questions in person?
Well, that's the big question is from a constitutional standpoint and from a precedent standpoint. Most legal scholars, and I agree with this, don't think that you can subpoena the president. I think that in a fight which would immediately go to the Supreme Court, they might lose that. And that's probably why Mueller has been seeking to get something more voluntary. Let's piecemeal it out, get some written answers first, and then, hey, Mr. President, we have some follow-up questions for you. They can certainly issue the subpoena. Nothing stops the grand jury from issuing it. But then the immediate thing that's going to happen is it's going to get appealed right away. And knowing Mueller's personality, I don't think he wants an unnecessary fight. Bad cases can make bad law. He'd like to avoid making a constitutional precedent here, and it'd be better to get a voluntary statement. But once those questions are answered, I mean, the president says, I think the problem is solved. It's not really a problem. It's part of the investigation. So the first step is answering questions, and then there are going to be follow-up questions. So it can't possibly just end right there.
Right.
Shannon, and correct me if I'm wrong here, if Mueller were to want to subpoena the president, that would require the acting attorney general's okay, would it not, to take that step? And if so, is it the president's impression that he now has kind of an insulating layer of protection with a friendlier acting AG?
I certainly think that's the case. The president doesn't seem to be saying that. But yeah, that's such an extraordinary step to have to take. It's such an unusual investigation if you're going to subpoena the president that absolutely the attorney general would need to approve that. And I think it's quite clear that Whitaker would not approve that. And what's really fascinating about that, Jim, is in many ways the special counsel operates as a miniature Justice Department. He has his own internal appellate people, Drebins over there. And they're certainly capable of taking on appellate issues that normally the SG's office would take on. So they could find themselves in an adversarial position willing to appeal the issue on their own, and that's where Whitaker really has to make a decision. Is he going to just come in and stop things?
Right.
Shan, thank you.